Title insurance. Title insurance is an insurance policy for protection against undiscoverable title defects, problems with the ownership of the property that exists at the time of closing, but will not or cannot be discovered in a title search. Example, forged deeds, undisclosed heirs, granting party lacked the capacity to grant title, etc. Title insurance companies often perform their own title searches using internal records called title plants and inform the insured of the status of the title via a preliminary report. Unless otherwise agreed upon, title insurance does not cover ownership issues that could be discovered by looking at the publicly available records for a property, such as zoning issues or publicly recorded restrictions. This means that title insurance companies often require that a property have a good and clear or marketable title, ownership free from any known defects, though they will sometimes also cover a property with insurable title, ownership with some known defects that an insurance company agrees to cover. An example of when insurable title might come up is when a title search reveals an undischarged mortgage from 1980. If it's this year, then it's highly unlikely that the bank is still waiting for that loan to be paid off. The title insurance company would then be willing to take a very low risk on that and insure the property even with a cloud on title. That said, insured title can create problems on resale because there is no guarantee that a future buyer or title insurance company will also accept insurable title. So buyers often prefer to only purchase properties with marketable title. For example, consider an undischarged mortgage from 1984. The title is unmarketable because of the unsatisfied mortgage. However, a title insurance underwriter may determine the title is insurable because it's unlikely the lender is still waiting on that loan to be paid off. On the exam, assume that known defects are not covered by title insurance unless otherwise specified in the question. Title insurance is paid as a one-time payment at closing, usually $2 to $4 per $1,000 of coverage. The title insurance company will then pay for any legal defense and provide financial protection against title claims for the owner and or lender. The title insurance company gains the right to defend against any title insurance claims, usually title-related lawsuits against the person who purchased the insurance by subrogation. The coverage provided by title insurance can vary, but generally it is either standard coverage or extended coverage, sometimes called an ATLA policy or American Land Title Association policy. Standard coverage covers basic title issues such as forged deeds, incompetent parties, delivery issues, or improper marital settlements. Extended coverage usually adds coverage for issues like tenants and squatters, survey issues, unrecorded easements and liens, and mineral and water rights claims. Title insurance is often offered as two separate policies: mortgagor or owner protection, which is protection for the purchaser to the full purchase price of property; mortgagee or lender protection for the lender up to the outstanding loan balance; and others. Okay. The Torrance System Land Court. The Torrance system is a way of addressing conflicts about property ownership. If petitioned in an action to quiet title, Land court will perform a title search and hold hearings to determine who owns a piece of property. In practice, this basically looks like a lawsuit. The parties to the case hire attorneys and go to land court to plead their case. The main difference is that land court cases are often complicated, slow, and rather expensive. Hence why people buy title insurance. Once land court decides who owns the property, it issues its decision as certificate of title, which registers the land. If land is registered, the person named on the certificate of title owns the land, overriding any other documents concerning the property. Transfers of registered land must be recorded. Any transfer of registered land is not valid until a new certificate of title is issued in the name of the new owner. As a rule of thumb, in the event of a dispute, the property transfer that is recorded usually wins, though possession or other circumstances can supersede recordation, so it's best to consult an attorney about this. Other methods of title transfer. Besides being sold, some of the other common ways real estate might be transferred are wills. Wills are how property of the deceased is transferred. Those who die with a will are said to be testate. Those who die without one are said to be intestate. Probate proceedings, the legal process by which the deceased belongings are distributed, generally takes place in the county where the deceased last resided, and or in the county where any real estate owned by the deceased at the time of death is located. The testator names an executor in the will to represent their estate. This is the person that carries out the deceased's last wishes. The executor devises or transfers real property to the devisees, heirs receiving real property, and their bequeaths, transfers of personal property to the bequest or legacy, to the legatees, heirs receiving their personal property. On the other hand, if the deceased passed in estate, then the courts will appoint an administrator to administer the estate. The laws of descent and distribution, or statutes of descent, will govern who receives the property of the deceased. Remember that if the deceased died in estate and did not have heirs, their property escheats to the state. See property rights limitation section for more. There are a number of other vocabulary terms to be familiar with regarding wills. Amendments to wills are known as codicils. Handwritten wills are referred to as holographic, in contrast to formal or witnessed wills. A verbal will is a nuncupative will and is not enforceable in most states. Property owned with a wife is said to be owned et ux. With a husband et con. Property owned with others is et al. Title transfer issues with probate property. Probate involves a legal process that can be lengthy and complicated. Agents must have a good understanding of probate laws and procedures in their jurisdiction to navigate these transactions effectively. Probate properties typically have multiple stakeholders, including heirs, executors, attorneys, and possibly creditors. Coordinating and communicating with all parties can be challenging. Title problems such as liens, claims, or dispute over ownership can arise with probate properties. In order for the property to transfer between parties, these issues must be resolved. Probate proceedings can take months or even years to conclude, delaying the sale of property. Agents should manage the expectations of both buyers and sellers regarding timelines. When working with probate properties, be aware of delays in probate court proceedings, unpaid estates taxes on the estate's side, disputes between family members regarding ownership that could cause delays, changes or last-minute updates to the will, whether or not the seller is legally allowed to sell the property, disputes over price between executor of the will and family members, someone assuming they're entitled to ownership of the property when they're not a joint tenant. Whether you are representing the buyer or the seller in a probate property sale, ask questions, gather documentation, and consult an attorney. Adverse possession. Adverse possession is the legal term for squatters' rights. If a piece of property is used openly and without permission for more than 20 years, the squatter may take legal title to the property. You can remember the rules about adverse possession with the acronym ONCHA: open, notorious, continuous, hostile, and adverse. Squatters' rights do not apply to public land or to registered land. Dedication. Dedication is the donation of property, ownership, rights of way, etc., either permanently or temporarily for the public use. For example, a donation of a piece of property to be used as a park. Okay, and that is part 2 of transfer of property.